between the two countries, Namibia and Angola. Investigation confirmed that there was indeed an agreement entered into, and before the agreement was signed, several meetings were held in Namibia, in Angola, with regarding to the project, which became known as the Namgomar project. The applicant before court, the evidence showed that he was part of the delegation that went to Angola together with Mr. Sakishangala, James Hatuikulipi, Thompson Hatuikulipi, and Johan Stephenson. On one meeting that was attended in Angola during a period of the 15 to 22 January 2014, the applicant was in the company of those people just I have mentioned, where discussions were made regarding this establishment of the bilateral agreement or the cooperation, business cooperation between the two countries. And as per evidence provided to us during the investigation, the applicant, Mr. James Hatuikulipi and Mr. Tassom Hatuikulipi and Mr. Saki Shangala, they were indicated as they have been representing Namgomar, a company called Namgomar from the Namibian side. So they went there as representative of the delegation or of the discussion to be done between Namibia and Angola on the bilateral agreement to be entered into. It is also evident that during that meeting, discussions were also done with regarding to the setting up of companies, both in Namibia and Angola, who would become a joint venture to that particular agreement. And the issue of the quotas to be obtained by those companies was also discussed. Okay, apart from the trips or the traveling to Angola, in the investigation I also mentioned that we obtained bank statements from different banking institutions. And among the bank statement obtained, the bank statement of the applicant and the bank statement of Namgomar Pesca Namibia were also obtained. We came to know the Namgomar Pesca Namibia, as it was mentioned through the allegations, and it was also indicated that it have entered into, it signed some agreements with the Sameri groups, or with Asia Holding Pty Ltd, which is a Sameri group company. The agreement I'm referring to, there was an agreement signed between a company known as Namgomar Pesca SA, and that was a cooperation agreement of which the applicant did also sign to that agreement. And another agreement that the applicant signed was a caching agreement.
Sorry, a what agreement?
Catching agreement.
Okay, the catching agreement.
Yes. This agreement was signed, if I'm not mistaken, on the 22nd of August 2014 during a meeting held in Iceland. The said meeting was also attended by the applicant with Mr. Saki Shangala, with Mr. Thompson Hatuikulipi, with Mr. James Hatuikulipi, and with Mr. Stephenson, who was representing the Sameri group. At that meeting in Iceland, the discussion was based on the bilateral agreement, which later we came to know as a memorandum of understanding that was signed by the two ministers, the former minister, Mr. Bernard Esau, who was a former minister of fisheries of Namibia, and Ms. Victoria, Ms. De Barros, who was a minister of fisheries in Angola. During that meeting, it was discussed. All Mr. Saki Shangala do a presentation with regarding to the awarding of the tender, or awarding of the quotas, or the signing of the agreement. And it also at the same meeting where a decision was taken that some of the money on the quota allocated, or some of the money from the Sameri group, should be paid from or to a company named Tundavala, which is based in Dubai. And this decision, as per the information provided, or as per the witness statement.
Of whom now? The witness statement of whom?
Of Mr. Stephenson. It was decided upon that 75% of payments on the quotas to be given to, or to be paid to be given to Tundavala, to be given to Namgomar Pesca. The 75% of that money should be paid from a company of Sameri in Cyprus to the company of James Hatuikulipi, which is Tundavala in Dubai. As mentioned before, the applicant was also part of the agreement with regarding to the users' fees to be paid in respect of the quotas to be given to Namgomar. During this agreement, it was decided that the 25% of the usage fee, which is equal to 500 Namibian dollar per metric ton, should be paid in Namibia, while 75% of the usage fee should be paid abroad. During the investigation or during the arrest of the accused, some of the accused persons in this matter, including the applicant, the cell phone was seized from Mr. James Atuikulipi during his time of arrest, and it was analyzed by one of our investigator analysts at the office.
Hello. I don't mean to interject, but this evidence he now wants to sneak in through the back door is literally what your lordship ruled inadmissible yesterday from page 65 onwards. I just want to jog the court's memory, my lord.
Yes.
So to go there is treading on very dangerous grounds.
I'm going to allow him to generally speak about that. That documents remain excluded.
Mr. Court, please.
That is, he's very clear in saying that it's information retracted from the cell phone of Mr. Atuikulipi.
I do take note of that, my lord, but the only reason I rise, my lord, is so that your lordship is reminded that,
Yeah, I am.
that this is what your lordship in any event excluded already.
Yeah.
That's all I'm saying, my lord. Mr. Court, please.
We appreciate that, Your Lordship, and we
I
also
don't want to. I don't want to break the narration of your client, and he's only referring orally to matters now. So, in that respect, he can go on.
as it pleases the court. Your Lordship, I think with the assistance of the court, insofar as bail applications are concerned, I appreciate that we could not lead this evidence insofar as Mr. Gustavo was concerned because he has no knowledge of it himself. We appreciate that. Insofar as the bail applications are concerned, the state has an obligation to put evidence before the court through the investigating officer to indicate that this is the nature of the evidence in our position that is going to be led at trial. So there's nothing wrong with the investigating officer putting that before the court. So insofar as this case is concerned...
Are you planning to put it before the court?
Yes, through the investigating officer, because that we are entitled to do, has, just to illustrate the nature of the state's case, because that we can do through the investigating officer who should testify on it.
Yes, that's what they received from the cell phone of Mr. Atuikulipi.
Yes, Your Lordship. On that basis, it's admissible. It can be dealt with. Because for purposes of the bail application, what the state should do is to show that this is the nature of the evidence in our possession. And that is what I intend to do with this witness regarding those messages, Your Lordship.
My lord, is my friend seeking.
If the state is going to say that that cell phone, what was obtained from that cell phone, from Mr. Atuikulipi, that particular information reveal that the applicant is connected to that. Is that what the state want to say?
No, what the state is going to say in this particular case, the message will speak for itself, for that particular message, because it involves Namgomar Pesca Namibia. So that message will nature effect speak for itself. And he's testifying on the evidence he has. He's testified regarding the witness who was involved when these negotiations were taking place. He is testifying with regard to the other possibly corroborating evidence which has been retrieved during the course of investigations. So there's nothing wrong to put that before the court.
Yes, counsel, I will allow it on that premise.
As it pleases the court.
But you can be alive that yeah.
I take note of that, my lord, but is my learned friend then in the same vein, literally asking this court to review its own decision from yesterday, where your lordship, faced with this information, already found that it is not relevant to these proceedings,
No,
and that it is highly prejudicial?
I did not find that it's not relevant to the proceedings. On the basis of what the applicant testified, that Mr. Atukulupi must speak for himself. It is obtained from his cell phone. On that basis, I excluded it. Now, maybe they want to bring a nexus. Let's see what they are going to bring.
They want to bring exactly that your lordship already said is inadmissible. Come on.
I'm going to leave the narration to go on at this stage.
As it pleases the court, your lordship.
It's not necessarily that I'm going to allow that document into evidence, but he can give his narration on the documents. He's the investigating officer. He reviewed it. He saw it. He made certain deductions. On that basis, he can go on.
As it pleases the court, your lordship.
My lord, what I just wanted to corroborate as to the evidence that we have collected through the investigation with regarding to the decision that was made, or to the agreement that was made.
Which agreement now, Commissioner?
The agreement on the usage fee
Yeah, that's before the court.
of the quotas, where it is alleged that it was agreed that 25% of the usage fee should be paid in Namibia, and the 75% should be paid outside Namibia. The evidence in our position, apart now from the extracted information from the cell phone of Mr. James Atuikulipi, that evidence was also corroborated by an email which was sent from Stephenson to Mr. Jurison of Samiri Group. They are all for Samiri Group,
Okay.
in which it was indicated by the Stephenson saying, they said 75% should be paid abroad and 25% should be paid in Namibia. So it's two documents corroborating the same evidence as it was alleged. The investigation with regarding to bank statements and the companies, the investigation revealed that at least Namgomar Pesca Namibia is an existing company which was registered in Namibia on the 21st of July 2014, of which the applicant before court is a sole director, and it was also established that the shareholder in the same company I mentioned is a company known as Namgomar Pesca Limitada, of which we found out that this company is an Angolan company, So Namgomar Pesca Limitada is a 100% shareholder of the Namgomar Pesca Namibia. And through investigation, we also established that as per the Memorandum of Understanding signed, quotas from the Ministry of Fisheries in Namibia was allocated to a company known as Namgomar Pesca SA, of which the applicant is also a director. During the nomination of the allocation of the quota to the company I just mentioned, Namgomar Pesca SA, there was a letter that was written from the Ministry of Fisheries and Marine Resources, signed by that time by the Permanent Secretary, the late Ms. Uritala Hiverwa, in which indicated that this letter was directed to the director of the company known as I think it's Poprent Investment CC stroke Namgomar Pesca.
Sorry.
The name of the director was not mentioned in that letter.
Poprent, you say
Investment-
CC,
So,
investment CC or
Investment-
PTY?
I think it's a PTY.
Okay. Sorry, you can go on.
During that nomination, the director was informed to make an application on the quotas to be allocated. But the investigation, that nomination, I think it was done 2014. And during that period, the investigation did not get any letter or retrieve any letter of such application. But based on the same letter, the 7,000 metric ton of horse mackerel quotas were allocated to a company, Namgomar Pesca SA, of which the applicant is a director. He did also acknowledge the recipient of that quotas by writing back to the ministry or to the permanent secretary, thanking them for such allocation. On the bank statement received from the bank, an analysis was done. At first, the analysis, we did it ourselves at the office
Which bank statement?
of Namgomar Pesca Namibia. And from the analysis, we found that in the account number of Namgomar Pesca Namibia, there were money coming in paid by a company known as Melmaria Seafood, which is also a company of the Samiri Group. And as per our analysis, an amount to a total of 38 million were deposited in that account.
38 million.
Plus minus 38 million,
Yeah.
Your Worship, my lord. Several withdrawals and transfers of the funds were made from that account. To the other companies, which we came to know through investigation that they also belong to the co-accused, the applicant in the case.
Belong to the
To the company belongs to James Hatuikulipi. One company is known as Grey Guard Investment,
yeah.
and the other company is Opafika Logistics, which is also a company owned by the co-accused to the applicant, Mr. Pius Matelulo. And other payments were made to the account of the applicant himself, which amounted to a total of plus minus 14 million. Apart from the 14 million that was transferred to the applicant's account,
Sorry, how many millions?
14 million,
14.
my lord. We also found out that some of the money were used in the construction of the house of the applicant by a company known as Visa Construction, totaling to an amount of more than 3 million. In total, if you put the amounts together in which the applicant benefited, he benefited to the total amount of more than 22 million. We also established that some of the money borrowed from or taken from the account of Namgomar to his personal accounts, they were indicated as loans. But we could not see that such loans were repaid back. There were no money coming into the Namgomar Pesca account, which can really determine to say or somebody to believe that those are loans that the applicant have taken and he have to repay them back. As I mentioned, these two cases were investigated together. We did also involve other stakeholders, like the taxation officers of the Ministry of Finance, to do their own internal investigation and provide documents and statements to us as to with regards to determine whether the applicant or Namgomar Pesca Namibia did pay tax on the income it received. We tasked the taxation officers who did their own investigation within their own ministry, and also who were involved in collecting bank statement on themselves to determine whether the tax was paid. By end of the investigation, a certain Mr. Aaron Kalinga, he gave a statement, and his evidence was that of the whole total of money that the company Namgomar Pesca received, they only declared plus minus 9 million. And the rest of the income was not declared, which I think it's they estimated totaling to 40 million. So that 40 million was not declared when the company gets its income from those quotas or from other sources. The flowing of the money, I have indicated that there was some money that was paid to Grey Guard Investment. A company belongs to Mr. James Hatui Kulipi. We also found out that that money did not only end up there. There was still another transfer that ended up in the account of the amount of 400,000. That ended up in the account of the former Minister of Justice's company or trust, which is called Omolo Trust.
Which former minister are you referring to?
I'm referring to Mr. Saki Shangala. He owned a trust which is known as Omolo Trust. And some of the money that was paid to Grey Guard by Namgomar Pesca Namibia ended up in that account.
Oh. All right.
That was an indication. Through our investigation, we could, apart from those money that I'm just mentioned to be transferred to the other companies within the Namibia, we could not establish any money flowing from that account, from the account of Namgomar Pesca Namibia to their shareholders, which is Namgomar Pesca Limitada in Angola. All the money received was used to the benefit of the accused person in this matter, including the applicant. And we could also establish that this Namgomar Pesca SA, which was receiving quotas from the Ministry of Fisheries and Marine Resources in Namibia, upon evidence presented to us, it was established that this company is not existing. It is a non-existing company which somebody can say that this company was just like a briefcase company, just established to get quotas to the benefit of the accused persons in the case.
Which company are you referring to?
Namgomar Pesca SA. It is a non-existent company.
So, I just want to clarify for myself.
Yes, my lord.
How was that established?
We are having a statement in our position which was submitted the time the former leading investigator was in charge of the case.
Is it a statement coming from a Namibian national?
It came from an Angolan national.
Okay.
Is that statement accompanied by any documentation?
Okay, the statement, if I can recall, it is accompanied by the documents of the company Namgomar Pesca Limited, which was found to be the shareholder of Namgomar Pesca Namibia.
And do you recall the position of the person who provided that statement?
I cannot recall as to what is his position.
But his role?
I cannot really confirm now as to what his role.
Oh, okay.
I just know that there was a statement taken accompanying those documents that were provided.
Oh, okay.
Sorry, but to clarify there, if the statement is from an Angolan national.
Yes, it is from an Angolan national. I have mentioned that quotas were given to this company that I say it was found to be not existing. And as from July 2014 to the fishing season of the year 2019, the Namgomar Pesca SA received quotas from the Ministry of Fisheries and Marine Resources in the total of 50,000 metric tons.
Is that now SA, Namgomar SA?
Yes, my lord.
Okay.
And these quotas, they were cashed as per agreement signed by the applicant, as per the cashing agreement signed by the applicant and Asia Holding for a duration of 10 years as it was agreed in the agreement, and on the payment of the usage fee of 500 Namibian dollars. What I can add on the agreement that was signed, or the amount agreed upon to be paid per metric ton, I want just to mention that the Asia Group during the same period of time, they have also entered into other agreements with Fishrot. And with Fishrot, The usage agreement was ranging between 1,500 per metric ton to 3,500 per metric ton of horse mackerel. Looking to the figures, you can really see that there was a difference, a very big difference on the agreement signed by the applicant with Asia and on the agreement signed by Asia with Fishrot. During the investigation, since this investigation was not only carried locally, and based on the allegation that it was agreed that some of the money should be paid abroad or outside Namibia, we make up some memorandum. We sent some MLS through the Minister of Justice, whereby we requested the foreign countries to provide us with information, especially on the account of Tundavala, and from the evidence we received so far, it was established that the Tundavala was indeed receiving money from the accounts of the Sameri Group companies, which was being paid in US dollars. And upon the investigation, the information provided, or the evidence at hand, the total amount of more than 4.1 was paid, 4.1 million US dollars was paid into that account. So far, we could not determine as to how this money was distributed, or how it was withdrawn, or whether it is still there.
Sorry, it was paid into which account?
Tundavala's
account?
Invest Limited in Dubai. From the two companies of Sameri, which is Asia Seafood and Katla Seafood.
Yeah.
All right. You also made reference to a joint venture.
Yes, correct.
What are your investigations insofar as that is concerned?
As our investigation is concerned, as per agreement, my understanding is that the company, Namgomar Pesca, Namibia, and Namgomar Pesca SA, which is an Angolan company, would form up a company in which they all become joint ventures. But so far as the investigation is concerned, we could not find or we could not establish that such a company was ever established. So, one can conclude that the quotas that Namgomar Pesca SA received was fraudulently received or was fraudulently awarded just to the benefit of the co-accused, to the applicant, which can also confirm the allegation being made for these key business people, top government officials, alleged to have been using this money or this memorandum of understanding that was signed corruptly just to benefit themselves.
Oh, okay. You had made reference to an agreement between Angola and Namibia, and you also made reference to it being an MOU.
That's correct.
Yes. Do you know how it came about for it to be an MOU instead of an agreement?
Okay, during the investigation, we got a statement from Dr. Albert Kawana. As we have approached him, to indicate whether the delegation that went to Angola, which was led by Mr. Saki Shangala, whom I can say he was the only government official there. According to Dr. Kawana, he said there was a draft agreement that was submitted to his office. By that time, I understand he was an attorney general, to give advice on the agreement before it was signed, to scrutinize it and to give advice. According to him, he explained that upon his scrutiny of the agreement, he found out that no, the Angolan part were not willing to enter into an agreement that is binding. So they prefer a non-binding agreement. That was his advice he gave to the former Minister of Fisheries and Marine Resources, Mr. Bernard Esau. And after such advice was given, they decided to downgrade the document from being a bilateral agreement to the memorandum of understanding. Memorandum, yes.
So, Commissioner, was it from your information is that from the Angolan side, the Angolans did not want to enter into a binding agreement?
That is correct, my lord.
Okay, thank you.
So The accused go ahead to downgrade such agreement to the Memorandum of Understanding, which they went ahead to let it be gazetted and this gazetting was done during July 2015. After the agreement or the Memorandum of Understanding was already signed on the 18th of June 2014. Which is also an indication that the quotas awarded to Namgomar Pesca Namibia during the year 2014, they were given on the Memorandum of Understanding that was never gazetted by that time.
All right. And I want to find out from you, this bilateral agreement was between two nations, Namibia and Angola.
Yes, correct.
What role did Mr. Jameson Hatwilipi, Mr. Ricardo Gustavo, and Mr. Temson Hatwilipi play, if any, in the government of the Republic of Namibia?
James Hatwilipi, Temson Hatwilipi, and the applicant in this matter they were never employed by the government of the Republic of Namibia, and they could also not be in a position to negotiate such Memorandum of Understanding, which is between the two governments.
Okay. Now, from the applicant's evidence, he indicated that the fish that was caught in Namibia belonged to Namgoma Limitada, and Estia, who sold it abroad, had paid the 500 Namibian dollars in Namibia, and this was not the purchase price for the quotas. What is your comment on that?
My comment on that, I will comment that as far as our investigation is concerned, we did not get any evidence proving that the quotas cashed in Namibia was indeed exported either to Angola in respect of Namgomar Pesca Limitada, nor did we get any evidence that such quotas or such fish were sold here in Namibia to the benefit of the Namibian people. And as per the Memorandum of Understanding that was signed, an indication was clearly made that this agreement will be entered into to secure food security and to create jobs. On the nationals of the two governments, which is Namibia and Angola, yes, we did not come across any documentation showing that Namgomar Pesca Namibia did ever employ Namibians, or they did ever employ or distribute fish in terms of food to the Namibian population.
All right. I also want your comment. The applicant also says that he was employed by Namgomar Limitada, and he at all times was acting on instruction of Mr. Joa Barros. What is your comment on that?
My comment is that I have seen maybe my Lord, let me Council just rephrase the question again.
Okay. What is your comment on the allegation that the applicant was employed by Namgomar Pesca Limitada, and he at all times acted on instruction of Mr. Joa Barros?
I never came across any instruction unless it was maybe done verbally.
Okay. All right. Insofar as this case is concerned, what is your attitude towards bail for the applicant?
My attitude towards the bail of the applicant, I am opposing to the granting of the bail.
Why?
I oppose bail due to the seriousness of this case. The applicant is facing serious charges, which is of corruption, money laundering, racketeering, fraud and theft. The amount involved in this case, in the Namgomar case, is a huge amount, of which, if the accused found guilty, can get a lengthy prison sentence. And I will also oppose bail for the reason that if the accused person granted bail, he may abscond. Reason being that, as per the evidence given, or as per the evidence we have, the state have in its possession at this moment, there is an indication that the accused person, he was born in Angola, and
Your indication, your information, was he born in Angola? The accused person?
my lord, that is the information the accused person gave himself, unless he was lying during the time he was charged. On the one statement he gave, he indicated that he was born in Lubango. That's why I said, as per his indication, I said he was born in Angola. Currently, the accused person is unemployed. He is not having any work here in Namibia anymore. His assets are under preservation. And there's a likelihood that these assets will also be forfeited to the state.
There's a likelihood that?
That his assets will be forfeited to the state. Since currently there's a preservation order put on his assets, which include the houses, the money in the accounts, as well as his vehicles. The accused person doesn't have any business ties here in Namibia. What can, except from the family that he's having, and for the sense that now the accused know what the charges he's facing and how the seriousness of the case is against him, there is a likelihood that if the accused is released on bail, he might be absconded.
What if bail conditions are imposed?
With regard to bail conditions, I have now experienced for long, before I even come to the Anti-Corruption Commission, that sometimes bail conditions are given. Let me say, for example, a person has been given a bail condition to say he must submit his traveling documents. Sometimes their lawyers or their legal representatives used to approach the court for such bail to be, the bail condition to be relaxed, which will end up for a passport to be handed back to its owner. In that way, the accused person can have a chance to skip the country. Sometimes, although bail conditions have been given, they are not honoring them. Especially if a person is really knowing that the offense I'm facing or the charges I'm facing are of a serious nature, and I may be sent to prison, the person can leave everything and go wherever he wants to go without that passport or without taking any note of those bail conditions. As I said, the charges faced by the accused person or by the applicant, they are serious charges. And by then, before the accused person was not arrested, he never knew the difficulties of staying in prison, as he is now feeling it. And if he released on bail, he will not be willing to go back to that place. Instead, you have to get other way where he can find himself that at this place I will be safe. And that can only be done if you escape the country.
So, sir, are you opposing bail because you are convinced that he will be found guilty and he will be sentenced to jail and he would not like to go back to jail?
With this evidence that we are having in possession, I am convinced that this person will be convicted. And he might be given a lengthy sentence.
Okay.
Yes, Lord.
Now, tell me about the evidence.
The evidence,
What I want to know is this. If you say that the investigation have information and or evidence, what quantum of that evidence, what people, persons, instances are compellable witnesses in Namibia?
the evidence I'm referring to that the state is having in possession is that the applicant or this accused person from what we are now alleging to be a corrupt practices or a corrupt activities, he benefited 22 million, which was received or which was received in dishonest manner and fraudulently as well. The cases, the charges he facing of racketeering are serious charges. And for the fact that these charges emanate from offenses that have been committed for a period of almost 6 years continuously. And for the benefit that himself and his other co-accused had received through the allocation of these quotas in a dishonest manner. Is there an overwhelming evidence to the judges put to the applicant? And that is the evidence I'm referring to, my Lord.
Okay, Commissioner, no, I appreciate your view of the evidence. I think I will take the matter up with counsel for the prosecution. The question that I posed to you, I will take it up with counsel in argument.
Insofar as this case is concerned, are there witnesses from Namibia?
Yes, in this case there are witnesses from Namibia. I convinced that the list of the witnesses in this matter was distributed to the defense of the accused person, if it is not for him, in himself, to himself.
Oh, okay.
Sorry, I must just say I did not receive the list of witnesses together with the charge sheet.
As it is
I
recorded.
actually have a copy for the court.
Okay.
All right. And from the Ministry of Fisheries and Marine Resources?
We do have witnesses there.
Okay. Do you recall how many witnesses from the ministry itself?
My Lord, I cannot give the exact total of the witnesses at the ministry, but they might be possibly more than 5.
Oh, okay.
There,
All right. Can you please inform the court what are your views with regard to the issues of public interest and interest of the administration of justice?
my view with regarding to the interest on the administration of justice and the public interest are that the applicant in this matter as per evidence gathered, he is one of the syndicate. He's one of the syndicate that just came together with a soul conspiracy to loot the marine resources of the country through their corrupt activities. Such activity or such offense that they have committed, it involves key public figures who were ministers, Mr. Bernard Esau, Mr. Saki Shanghala, who were elected and put in position of trust, entrusted to serve the Namibian government and its people, through the laws enacted by the Parliament of the Republic of Namibia. And they went to such an extent to change the law, especially the Marine Resource Act, just to their own benefits. And although the advice was given for them by the authority not to go ahead with the agreement, which they downgraded to the Memorandum of Understanding, they showed disrespect of the law. They decide to manipulate the system or the law to come up with the agreement which will only benefit them. And they also the two key figures.
Sorry, what are the key figures?
The key persons, let me say.
Yeah.
The two former ministers. Who start with the orchestrating of this agreement? My lords, when this matter came up, or when this information regarding this case came up, through the medias, through the Al Jazeera reports, there was anger among the Namibian people as to the involvement of the ministers who were put in positions to serve them, but I said, at the end, they did not deliver what the nation of Namibia have expected. It was not only through Namgomar where these accused people did benefit. As the amendment of the law was not only made for Namgomar, it same also happened with Fishrot, in the case of Fishrot, where the two ministers with other co-accused, they agreed to such an agreement that will enable them to allocate quotas fraudulently, corruptly, and such quotas also end up benefiting themselves. And these quotas were given through what was termed as government objectives, with the sole purpose of providing drought relief to the Namibian people or to any other state in need. But still, they decided to take that advantage. People were demonstrating when the applicant came to apply bail in the first place, or during the first time. They will feel anger as to what had happened. And now, if they start seeing these people or these accused people walking in the street, knowingly know what they have did, or knowingly that this person was in custody because of ABC or because of the offenses he committed, which is also of a serious nature, it might give impression to the people that people in higher positions, on which the people are now terming to call them big fishes, they are untouchable. they will have that impression, and they will not blame anybody rather than the state. That's why I say it's not in the interest of the public, nor in the administrative of justice, for the accused person or the applicant to be granted bail.
So the applicant is under that umbrella, also of the public
He is also
figures, under that umbrella.
He is also under that umbrella, my lord.
How long were you in the police force before you came to the Anti-Corruption Commission, Commissioner?
I have been there for almost 8 years, I think.
8 years, yeah. Now, you are the chief investigator in this particular case, or not?
Yes, my lord.
Chief investigator.
Chief investigator.
Now, after these two cases were consolidated, the Namgomar and the Fishrot case, how many witnesses do we have in this case?
The witnesses that we will have, there might be more than 150 witnesses.
Okay. Now, I'm not going to ask you about trial dates, but there is more than 150 witnesses, you say?
Yes, my lord.
Okay. How many accused do we have in this case? Just talk about the natural persons, not the companies.
We're having 10.
10. Okay.
Yes, my lord.
And you, in the bail applications, you have encountered already different sets of legal practitioners. Different sets of legal practitioners representing different accused, not so?
Yes, my lord.
Yes, okay. Now, I want an estimate from you and your experience as a police officer, then coming to the Anti-Corruption Commission. You know what is the quantum of charges, the quantum of witnesses. How long do you think will such a case like this one take before it's one day finalized? Or don't you want to guess?
My lord, I don't want to guess,
Okay.
because this will just be depend on how the case is proceeding in court.
Yeah. And whether one judge are going to be allocated to the whole case to give his full time to this case.
Yes, my lord.
Yes. We had other big cases in the past where a lot of people were arraigned together on common purpose, like the high treason trial. That trial took a very long time, not so?
Yes, my lord.
About 13 years. Do you think, and I'm just asking your opinion as investigating officer, the weight the council will address me on, do you think a case like this will take less than 3 or 4 years to complete with a full-time judge?
If it is with a full-time judge, I don't think it will take to 4 years.
Okay. I will take the matter up in any event with counsel in argument. Thank you.
All right. Is there anything else you wanted to say on public interest? Or you are done?
What I want to say on the public interest, I just want to say that the state had been put on the scale by the public. The public is expecting what they want to see, whether this case will really be handled without any disturbance, without any hindrance until its conclusion. And they are also expecting to see whether the state is really having that capacity of being impartial when handling the cases, as there are already an impression that people in high positions, they are not really held accountable to the corrupt activities. So that could be one of the expectations the state, the public will want to see.
Sir, and you as investigating officer, do you know when this corrupt practices in this particular case not particular case, in this fishery looting matter, do you know when that was the first time reported, or was it before your time? I'm not talking about the whistleblower now. I'm not talking about Al Jazeera now. Were there people in Namibia who reported this corrupt activities?
I think the corruption activity was reported long back. I think by 2014, around there. But it seems during that period, there was no proper information provided, like the one that just came to be brought up by the whistleblower.
By?
By the whistleblower, by Stephenson. And that was done only 2019. I know the investigation was being done on the matter, but it seems it was a misdirected investigation. Where they were facing is not where this information was found. They were misdirected. But there was such a report made with regard to fisheries.
Okay.
Do you recall what was the nature of the complaint that was there in 2014?
I just read about it, that the nature of the complaint, it was also related to quotas that were being taken from the companies that are having rights, or let me say, that were taken from the right holders, then given to companies that are non-right holders. I think that is the complaint was based on that.
Okay, but you knew about that, but during that time, where you say the investigation was misdirected, you were not involved.
I was not involved.
You only came in August 2019.
Yes, my lord.
To that. Thank you.
In your experience as a police officer and as an investigator at the ACC, what is your experience? Do you have an example with people who have been charged with serious offenses and have absconded?
Yeah. I have an example of the case that I just came to be aware of when I met the Anti-Corruption Commission. This case was of a state versus a certain Maria Kutsie. This person was charged for fraud involving 3.8 million. The case was carried out by the investigation was carried out by the Commercial Crime Investigation Unit of the Namibian Police. This woman is a Namibian, and she was granted bail in that matter. The case was also in the High Court. I can recall one of the bail conditions that was given is that she must hand over his passport to the investigating officer. But as per information provided by the investigating officer, at one time, the investigating officer got information that no, this lady is planning to leave the country. The investigating officer managed to apprehend that woman at the airport. She was placed back in custody, but due to apparent health conditions, she was again given bail. As we are talking today, since last year, I think April, somewhere there, that woman, she left the country to South Africa. And the people are now busy trying to locate her and to go through the extradition process if she found. That is just an indication to say, although bail conditions have been put, people can still abscond.
And you are afraid the applicant may abscond to Angola?
He may also abscond to Angola.
Do you know whether there's an extradition agreement with Angola by our government?
I don't know, my lord.
Yes, I also not.
But I always see a possibility that for him to enter into Angola is a very easy thing. Because Namibia and Angola, one can enter another country for approximately 20 kilos. You don't need to have a passport. If I go from Oshikango to Onjiva, I can go without a passport, a Namibian.
Yes, Commissioner, I hear what you say. If an applicant for bail or an accused person, which have, not only talking about this applicant, which have Angolan ties, if he's given bail and there's serious crimes, if he's given bail and the court would say, look, you will not be allowed to go outside the perimeters of Windhoek. You will not be allowed to go near the perimeters of any airport. If a court puts strict conditions on movement,
My Lord,
what's your view about that?
strong conditions can be put, but it's only that such a person need to be monitored every time, which can also not be another additional task.
An additional task, not to, you don't want that additional task.
Not my Lord. I feel that we need to have a secure place for this person. And we are still having a secure place for him where he is currently detained.
Commissioner, with how many members of the public did you have discussions to form a view on behalf of the public?
I did not make any discussion.
You did not have discussions with the general public about this case, or did you have?
I did not.
Okay. Further questions, Council?
Insofar as this case is concerned, are there any outstanding warrants of arrest?
We have warrant of arrest of the 3 suspects from the Samiri group, which we have already submitted to the Ministry of Justice to deal with the extradition. This is now only on the Namgomar case. On the Fishrot case, we still have 1 suspect, Mr. Marine de Klerk, who is believed to be in South Africa. And the extradition process have also started. It's only that my experience is that when somebody has to go for extradition, it's something that can take a very, very long process. That's why I don't ask to, or the court to release suspects in this matter on bail. Yes, we may end up in the same process, which might delay this case, and which will also not be in the interest of justice.
Are you going to wait for Mr. Marine de Klerk to be extradited before this case will start?
No, my lord.
Okay.
Now, do you know the citizenship of Mr. de Klerk, who is currently at large?
Mr. de Klerk is having a dual citizenship. He's a Namibian and he's also a South African.
All right. And what can you inform the court with regard to interference in this matter or interference with witnesses?
With regard to the interference with the witnesses, I will say that the accused person or the applicant He is in this matter with his other co-accused. He knows some of the witnesses in this matter. And he may also know some of the witnesses who are friends to his co-accused. And I'm of the view that if this person had been given liberty to stay outside of the prison, or if he's granted bail, he will be able to communicate with the witnesses. He will be able to get instructions from his co-accused to approach some of the witnesses. Currently, we have cases that we went through where witnesses are being approached to change their statements when they are coming for testifying. We also experience that witnesses, like I say, they might be tempted to check the evidence on the cases, especially those who have been working closely to these people, to the accused people. And interference can also be with regard to the case itself. Where people can be approached. Previously, we have 2 instances where a person was sent by Mr. Saki Shangala to collect documents from his house that were of evidential to this case. Or to the, we are having another instance where Mr. James Atuikulipi sent another person to come and bribe an ACC official for him to give him some of the evidence in this matter. So by the looking of the applicant, I see him, he's an intellectual person. And I see his capability. Of tampering with the evidence in this matter, or his capability of doing anything of which he will come by end of the day to come and justify the allegations made against him.
Okay. Your Lordship, I don't know, the states bundle, that was submitted as exhibit.
Say again?
The exhibit number for the states bundle.
For that?
States bundle, the one that was submitted yesterday.
The last one?
Yes, Your Lordship.
Okay, can you give me an indication how long it will still be with this witness?
I'm almost done. I just want to ask
Okay.
him 1 or 2 questions on this.
Are you talking about Exhibit R?
Yes,
The one with the emails?
Yes, Your Lordship.
Okay, this is the one that you brought yesterday morning.
Yes, Your Lordship.
Okay.
The one that was submitted.
Exhibit R?
Sorry.
Counsel, just reflect. I followed as he went forward, and the bundle is before the court.
Yes, no, I'm not asking on the contents. I just want to ask a general question.
Yes, but let's move it on.
Yes, Your Lordship.
All the things he referred to, I remember from the exhibits, from the evidence.
Yes, Your Lordship.
I will be able to locate it.
As it is, Your Court.
Yes.
But I'm not going through. I just wanted to ask him just a general
Yes.
question on the. Do you recognize those documents contained therein?
Yes, I recognize the documents.
All right. Is that part of the evidence collected in this case?
Yes, my lord, this is part of the evidence collected.
All right. Thank you. Your Lordship, there are no further questions
Yes,
from the
thank
state.
you. Counsel, before you start cross-examination, I think we should stand down now for, how long do you think? Quarter of an hour, half an hour? Why I'm going to a bit longer time, maybe half an hour. I want to suggest, and I don't want to prescribe to you, having regard to the time left, is it possible that you can consider conducting your cross-examination by way of, I state to you, I state to you, I state to you, and getting comments? Or do you want to go into an formal examination?
My Lord, I have my own way of doing things, my Lord.
Yeah.
But I will definitely, by 4 o'clock, I'll be done with him. I can guarantee the court that, my Lord.
Why 4 o'clock? I thought
There's
by
a
1
lot
o'clock.
that he had to say. So we have to canvass some of these averments, my Lord. Unfortunately so.
Yes, unfortunately so. Now, while we are, now I must do it in open court. When will we be able to go on?
My Lord, as far as the evidence is concerned, I believe we will finalize today.
Yeah.
And we can get a future date, let's say in a week or two, but depending on your Lordship's availability for us to do submissions.
No, and it's your availability and council's availability.
I think we are available next week for submissions. We can do that. If he finds the evidence, we can submit next week, Your Lordship.
Okay.
Yes, my Lord.
I heard something from my assistant that you have asked for records. I don't know how it's done in criminal cases, really. My feeling was, and I think that was conveyed to you, that the transcription, if you want it, you can ask it, and it should be paid half by the prosecution and half by the applicant or the defense.
My Lord, we have no qualms. In fact, I already submitted a request form this morning
Yes.
for us, because I deem it important. There
Yes.
is a lot of documents submitted that I actually want to refer to, my Lord.
Yes, but
Yes. And the context thereof.
in the context, but I want to take it a little bit further. When we request a transcription, are counsel going to ask me that the transcription must first be done before they want to deliver their submissions? Or can you do your submissions without the transcription?
My Lord, we are in a position to
do that.
To proceed without that.
Yes.
But of course, it just enhances the position where I can direct your Lordship and say, on this page, specifically, this evidence
Yes,
is.
I know, but
Yes.
again, time. We don't know when it will be done. We don't know when it will be proofread. The dates that I will agree with you concerning argument might be strongly impeded by the availability of the record. I know you have someone here behind you all the time. that help you with notes. I know there were 2 counsel involved. So I believe counsel will be able to give their submissions.
As the court pleases.
Remember, if you examine this witness now, remember still it's a bail application. It is not a trial.
I take note of that.
And counsel, leave room for re-examination. If you tell me you will be busy until 4 o'clock, then we have a problem. So I put that to counsel.
Lord, I will
We
try
have time
as far as
constraints.
possible
Yes.
to give them at least half an hour.
Yes, you can agree about that. Okay, counsel. We stand down until, let's make it 11:30. It was a long time. 11:30, and then we restart again.
Court please.
The matter is adjourned until 11:30. Where's my
Lord, I just
glasses?
produced the copy of the list of witnesses your Lordship was asking for.
Okay, thank you.
Thank you. Now, may I proceed, my Lord?
Yes, you may.
Thank you. Mr. Kanyangela, I want us to start at the genesis, the beginning of the matter. Now, it is your evidence that you are employed with the ACC for 11 years. That is so? You must answer it's recording, Mr. Kanyangela.
Yes.
Okay. And you were appointed, if my understanding of the legislative framework is correct, in terms of the Anti-Corruption Act.
That's correct.
You must also speak up so we can hear you, please. More specifically, under the provisions of Section 13.
You are correct.
Okay. And your functions, sir, are within the 4 corners of the Anti-Corruption Act.
That's correct.
Okay? Do we still have it on good record that you took over the matter at hand during August 2019?
That's correct.
Okay. In August, if I understand them correctly, there was already an ongoing investigation and you just took it over as the investigating officer.
Yes, it's correct.
Okay? Now, up until that point in time, or when you came, you said you were the lead investigator now of a team.
Yes.
Okay? This investigation was within the Anti-Corruption Commission.
Yes.
Okay? So you took over and led a team of investigators of the ACC.
That's correct, yeah.
Okay. And the matter progressed. By the 22nd of November, sir, you felt now that you had enough evidence to apply for a warrant for the arrest of the applicant before court.
That's correct.
Okay? Now I want you to look at this document, sir. It's the affidavit that you filed in support of the warrant of arrest. And just confirm whether this is firstly your affidavit. It comes from the state's disclosure.
Yes, that is my affidavit.
Okay? And on the strength of that document, sir, you advised the court or the magistrate who issued the warrant of arrest. If we look at paragraph 2, sir. Yes, just at the top. That you are the lead investigator as set out in this affidavit. That is so.
Yes.
You further informed that the Anti-Corruption Commission is investigating allegations of corruption, money laundering and fraud in relation to the awarding of quotas to a Namibian business, Namgomar Pesca. Do you see
Yes.
that?
That's correct.
Okay. So on the basis of this document, sir, a warrant was issued. That is so?
That's correct.
Okay. And the applicant was arrested on the 23rd of November 2019.
You are correct.
Okay. Now, am I further correct, sir, that the very next day, the 24th, there was an urgent application in the High Court challenging that warrant?
Yes, you are correct.
Okay? And the basis upon which it was challenged was that, firstly, you have no powers in terms of the Criminal Procedure Act under Section 43 to apply for a warrant. That is so?
It is not so.
I have the actual affidavit. I can produce that for you. And then secondly, sir, that you are not in a position to investigate any offense under POCA. Are you aware of that?
I'm aware of that,
Okay.
but if it emanates from the corrupt practice that we are investigating, we can do that.
In fact, sir, I have in my possession further an order of this court, sir, confirming that position, that you were not to investigate offense, or you could not apply under Section 43 of the CPA and not to investigate matters from POCA. Just have a look at that, sir. Here's a copy. Comment if you have any. Maybe you want the founding affidavit as well?
Whose founding affidavit is that?
In that application, my lord, from Mr. SA, where they challenged those warrants on those bases, my lord.
Okay, I don't think the founding affidavit is relevant here. Yes, Counsel.
Yes, Your Lordship, I want Counsel just to show us where in this order it says that they cannot investigate charges of money laundering. I don't see it anywhere in the order.
Okay.
No, my lord, the order says clearly that the warrants are set aside, declared invalid and set aside. And it was challenged on a specific basis.
Yes, it was challenged, but then there was an agreement, and because of the agreement, the matter was set aside.
That is so, my lord. But that is not the final basis of where I'm going. Okay, you see that? Now, Mr. Kanyangela, it is correct further that the applicant was released on the 24th.
It is correct.
Okay? You went back and on the 26th of November, sir, you filed a new affidavit this time.
Yes.
Who filed the new affidavit?
The same witness, my lord. You see that, Mr. Kanyangela?
I see that.
Okay. I will draw your attention again to paragraph 2. You see that?
Yes, I see.
This time you are saying, I'm the lead investigator of the allegations of corrupt practices as set out in the affidavit. You follow?
Yes, I follow.
Okay. In this one, you do not say you're investigating corruption, money laundering, and fraud.
Yes, correct.
Okay? So there's a material change if we accept those papers on the face value, sir.
Yes, correct.
Okay. So I'm saying to you, Mr. Kanyangela, that you willfully misrepresented to the magistrate or officer to get the second warrant, sir. Because you knew the High Court had indicated that you were not supposed to act the way you did in the first affidavit. Comment if you have
It was not a misrepresentation.
Okay. My lord, if there's no objection, I want this handed up. Just for that specific point that I just raised now.
That is now the two warrants.
The two applications, my lord, that he filed.
The warrant with the affidavit.
My lord, I only have the affidavits with me.
Okay, the affidavit. Okay. Counsel, any problem?
There's no objection, Your Lordship.
Thank you.
Thank you, my
Can be
lord.
handed up. It will be S1 and S2.
Thank you, my lord. In fact, the court order that's in the middle can also go with, so we can do S1, S2, and S3
Okay.
to show a proper pattern, my lord.
Okay.
Now, Mr. Kanyangela, before I move,
And you will provide me with copies of that.
yes, those ones that he has, my lord, I'll be looking to them. First example. Okay. Now, sir, to dispel the myth that you attempt to create, I want to give you the ID of Mr. Gustavo. Have a look at it. Second. You see that?
I see that.
That is a national ID document
That's correct.
for the Republic of Namibia.
That's correct.
Please read place of birth. What does it say?
Oshakati.
That is a place within the Republic of Namibia.
That's correct.
Okay. So, sir,
Can I say something on it?
Yes, let him say something.
yes, what do you want to say?
What I want to say is that this ID was provided based on the late application of birth, of which, to my knowledge, a person can be born in another country and come to apply for a birth certificate in another country. And if it was the lie that I said, maybe it is came from your client, from the applicant when he was being charged.
You see, Mr. Kanyangela, no, continue. Let's first finish your part.
No, I'm done.
Okay. You see, sir, in fact, my instruction is on that score. That you asked him where, because you saw his name, where his parents originate from. And he said to you, they are from Angola. But I'm a Namibian. I was born here and raised here. And you wrote on your own, Angola, sir.
I never wrote such.
Yes.
Wait,
On the warning statement, sir.
I never charged him.
Okay? But be that as it may, sir. My lord, I don't think there's an objection that I produce a copy thereof.
Yes.
Yeah, it's for the court. Please give my ID back. Thank you. Now, Mr.
This will be then T, Exhibit T.
Indeed, so, my lord.
Counsel. Exhibit T.
As it please the court, Your Lordship.
Mr. Kanyangela, I first want us to deal with the issue of abscondment. We'll move accordingly. Now, it is your assertion that the applicant will abscond. That is so?
Yes,
Okay. During your investigations, you established that the applicant has a residence in Windhoek. That is so?
correct.
In fact, it's Erf 229 Finkenstein.
You are correct.
Okay? You further established that his parents live in Windhoek.
I never established us.
Okay? But it's on record in the initial bail application from your colleague, Mr. Kluter. So that's not an issue. Did you take the time to establish that he has 5 children, all resident of Windhoek?
Yes, I did.
Okay. You further took the time, sir, to establish that he has 4 siblings, himself and 4 siblings.
Yes, I did.
Okay. And they're all resident of Windhoek.
You are correct.
Okay. So, sir, as far as his family goes, his whole family is within the locality of the Windhoek municipality. As far as you know now.
Yes.
Okay. So, sir, can we agree that he has strong ties to Windhoek? If not the whole Namibia, but at least Windhoek.
Just because of the family, yes.
Okay. In fact, sir, you made further assertions that all of his assets are subject to restraint order. That is so?
Yes.
Okay. And that those assets are all in Windhoek.
That's correct.
Okay. You don't know of a house in Oshakati or Oranyamund?
I don't.
Okay. So as far as you are concerned, everything is here. Financial and family. Yes?
Yes.
Okay. Now, my lord, I will argue the rest. There's really no point in pursuing that further. Now, let's move on to the next ground, sir. The issue of tampering and or interference as raised by the state.
Yes.
Okay? It is correct that disclosure was made in this matter.
That's correct.
Okay? You, in conjunction with the state, advised on the 14th of December last year that your investigations was finalized. That is so?
That's correct.
Okay? And all of your witnesses, sir, gave actual witness statements, which you disclosed.
Yeah, they give witness statements.
Okay? That's fine. And from the beginning of this matter, sir, that is 23 November, the initial arrest,
Yes.
the applicant before court did not hide any information, as far as you know. Yes?
Hide any information.
Or destroy anything.
Yes, he did
Okay.
not.
He was not charged for attempting to speak to any witness.
No, he was never judged.
Okay. He also never, be it from prison or outside, tried to influence any witness whatsoever.
Not.
Okay. So, to date, sir, from 23rd of November 2019 up to now, sir, this applicant has not at any point in time attempted to interfere with your ongoing investigations.
That's correct.
Okay? Now, in those circumstances, sir, it is my instructions that there is nothing to support your contention that he will interfere with any investigations whatsoever.
I can say just from the time you mentioned the applicant in this matter he was not aware of the evidence against him the state is having.
Okay.
And by now, he knows what was put to him. He knows of the evidence in possession of the state. He might know some of the witnesses in this matter based on the disclosure.
Okay. I'll come back to that. Now just rewind to the previous aspect. There's just one thing I left out, sir. It is factually correct that he was released from custody on the 24th of November, that we have canvassed. That is so?
Yeah, that is correct.
Okay. And he was rearrested on the 27th of November.
That's correct.
Okay. So, factually, he was a free man for 3 days. That is so? Or 4 days?
You are correct.
Okay. And during that period, sir, knowing that there were these allegations against him, he did not abscond.
Yes, he did not.
Okay? In fact, my instruction is that at the time when you received your warrants, he was actually on his way to Swakopmund. Do you know about this?
I don't know.
Okay? And then he received a call to come back and report himself to be rearrested. Are you aware of this, sir?
I just know that he came with his lawyer to be arrested.
Okay. So from Karabab he turns back, comes to be rearrested. He does not attempt to flee. At least let's agree on that.
Yeah, I can agree.
Okay.
Objection, Your Lordship. I did not hear my colleague clearly. Is he referring to the evidence of the applicant who testified that was tricked the second time that he came to be rearrested? Or is this an instruction now that he's received from his client, contrary to the evidence that he testified?
There's a part that he came back to be rearrested, is that?
Yes, that's
what you
the
are
part
referring-
to be rearrested.
I think you stated wrongly. That was not the evidence.
My Lord, some of these
There
objections are
there
neither
is
here
a
nor there.
deduction you made because he was factually afterwards arrested.
It's in order, my Lord. So he was called to come back to the police.
Correct.
Yes.
To come and answer questions. That was the evidence.
Be that as it may. Thank you, my Lord. So, he was called back on the 27th, be it for interrogation or for an arrest. Come on, man.
Say again?
We'll leave it at interrogation. Have a seat.
Okay.
Yeah. So he was called back for an interrogation with you or the police.
Yes, I know he came back.
Okay. So my instruction is, sir, just to make it clear, that he was actually on his way to Swakopmund and turned around from Karabab to come back to you.
That can be possible.
Okay. So, to close off that point, sir, if he wanted to run at that point in time, or any time during those 4 days, he had ample time and opportunity to do so. Comment if you have any.
I will comment by saying, by the time you are referring to, the applicant was not knowing the evidence the state is having and the charges that were currently put to him as per the indictment. And by then, he did also not experience that thing of being in prison. That is a thing that can convince him. And he might feel that by that time, he might feel that the state might not have a strong case against him. And I don't know whether I have to say this, but if the court can allow, I can say that. There was an expression that we are not having such capacity of investigating such corrupt practices in which they involved. All those can convince him to come back.
Excuse me? Who made what expression?
Some of the accused in
Not
the
him.
matter, not him.
Okay. Now, let's just delve a little bit forward, sir. Your investigations, if we understand correctly, established that there was an entity by the name of Namgomar Pesca Limited.
That's correct.
Okay? This entity was owned by Angolan nationals.
That's correct.
Okay? This entity has a subsidiary in Namibia called Namgomar Pesca Namibia. Yes? You must answer, it's recording, Mr. Kanyangela.
Yeah, it's the entity. Yeah.
Okay. And that entity is the entity where the applicant was a director/employee.
Oh, correct.
Okay. So, did you, during your investigations, establish that João Barros was involved with Namgomar Pesca Limitada?
Yes, documentation was so submitted.
So you cannot dispute that point.
I cannot dispute it.
Okay. In fact, the instruction is that João Barros was the person in charge of the operations of Namgomar Pesca Limitada.
I cannot dispute that.
Okay? And that is the person that he reported to. You can also not dispute that.
I can't.
Okay. Now, I'll park that and we'll come back. As part of your affidavit in the POCA proceedings, sir, you produced a protocol on fisheries and aquaculture. That is so? It's already before court, my lord.
It is so.
Okay. And that was the initial agreement that governed the relationship between Namibia and Angola from 2007 to 2012.
That's correct.
Okay? We can assess and agree that during that period, this applicant before court was nowhere near the fishing industry, as far as your knowledge goes.
That's correct.
Okay. Also submitted, sir, is minutes of a meeting. It was also part of your application, sir, or your affidavit in the POCA application, where the counterparts were in the process of renewing this agreement.
That's correct.
Okay? And this was around June of 2013.
Cannot recall the date.
It is before court. So the issue is not about the date. But you agree that during 2013, around the middle of the year, there were these discussions.
Yes.
Okay. Now, as far as your investigation is concerned, sir, you cannot dispute that the applicant before court became involved with Namgomar, the Angolan entity, during the last quarter of 2013.
Possibly, yeah.
Okay? So this is after these negotiations between two sovereigns. That is so?
Oh. Think back. I may say that the meeting you're referring to, it was not. I cannot confirm of being related to this current agreement we're dealing with.
Mr. Kanyangela. Lord, I just quickly want to find it. Maybe just to refresh his memory. Lord, it's actually, it would be exhibit C-T-E, my Lord, if my memory is correct. I can actually just provide it to him.
Are you referring to the MOU now?
No, my lord, the document that precedes the MOU.
Okay.
Because I handed them in protocol,
Yeah.
the minutes, and then the MOU. They were in that sequence, my lord.
The protocol was D.
And E would then be the minutes, my lord.
Let's see.
My lord, it says at the top, minutes of the meeting between the ministerial delegations.
That was E, yes.
Yes, my lord. Do you see that?
Yes, I see it. I see it, but I don't see any reference made to this
Yes.
agreement we are busy with.
Okay. But at least what you see is two governments discussing cooperation in the sphere of fisheries and aquaculture.
No, correct.
Okay. And this is during 2013. That is so?
That's correct.
Okay. And the memorandum of understanding, which you call it, was signed in 2014.
That's correct.
So that agreement follows on from these discussions.
I cannot confirm that.
Okay. No, it's your choice not to confirm, sir. We're all not blind. We can see ourselves. So there's a protocol that expires in 2012. There's a discussion in 2013 pertaining to, I would call it a renewal of this agreement. And then an MOU is signed that almost literally 95% mirrors the protocol, sir. Comment if you have any.
I can just comment that this meeting was based on the review of the old protocol you are referring to.
So this meeting was based on the review of the old protocol. Yes. And subsequent to that, another agreement is signed.
That is what happened.
Okay. So, sir, firstly, the 2014 agreement, in light of these circumstances, could not have been the brainchild or influenced by this applicant before you. Can we at least agree on that?
No, it cannot.
Okay.
You say you cannot.
Yes, it cannot be influenced by him.
Okay, fine, let's carry on.
In fact, sir, this agreement was done between two sovereign states, nothing to do with this applicant. That is so?
Which agreement are you referring to now?
This MOU.
Yes, it was agreement between the two states. But if you can see some of the people involved, they are not employee of the state. It's something that I can say, if it was discussed, or if it was to be discussed between the ministries of the two countries, then possibly it was hijacked by the accused person in this matter.
Sir,
Because they were not employee of the government.
this is my instruction, sir. And
Then possibly it was what?
hijacked, like a carjacking, man.
Okay. That's why I say be careful. I heard a lot of speculations already. It's not necessary to put more speculation and opinion
I
on
appreciate
my
that,
record.
And I was just going to say that to him now.
Yes.
So, that is merely your opinion. The applicant denies any involvement whatsoever in those processes.
Let me end up with my opinion.
Yes. Now, sir, it is common cause that yourself, you were not involved in any of the apparent discussions, be it bilateral or in Iceland or any of the above. That is so.
I was not involved.
Yes. So anything and everything you have to say, sir, at this juncture, sir, comes from third parties. That is so?
That's correct.
Okay. Now, my instruction is, sir, that the applicant before court at no point in time participated in any discussions about offshore payments. Comment if you have any.
I will comment by saying if people are going out for a delegation to a certain country, I will not see that they can just go without first discussing what they are going to present on the other side. That's why I still believe that the meeting that was held in Iceland, where some of this, the 75% to be paid outside was discussed, I understand that since he was part of the delegation, he may also would also be part of the people who discuss this matter.
So that is denied in the strongest terms. But I want to bring you a little bit closer. You are aware of the fact that there was a cooperation agreement between Samerji as a group and Namgomar Limitada. You are aware of that?
Sameri and Namgomar Limited.
Yes.
I'm not aware.
Okay. You can provide your copy. Then his friend does not mind. It's right there. Let me just show you. It's in that book. And it's before court already. Let's finish court. It's actually Namgomar Pesca SA.
I thought you mentioned Namgomar Limited.
No, I'm saying to you, sir, that the agreement reflects Namgomar Pesca SA.
Hence, I could not believe that, I could not agree that it was between Namgomar Limited and Namgomar SA. If it is reading Namgomar Pesca SA, I could not say it's the same agreement between Asia and Namgomar Limited, as you put it.
I said to you, sir, that there is a written agreement, cooperation agreement, which is already before court, sir, between Namgomar Pesca SA and Asia.
You said Namgomar Pesca Limited.
Let's leave the semantics, sir. Let's focus on the issues. What I'm saying to you is, Namgomar as a holding company and Asia, if that satisfies you, sir.
No, but I think we have to stick it to what is on the document.
And that is what I'm showing you.
There's no Namgomar Limited there.
Be that as it may, sir, the court takes its own cognizance, my lord. This cooperation agreement, sir, makes provision for multiple agreements. That is so?
Yes.
Okay. There is the catching part, that is so. Then there's the distribution part. Yes?
Yes.
Okay. I just quickly want to see. It has a packaging and storage component.
Yes, that is what is written, but I never see any agreement.
It comes from the disclosure, sir.
No,
So
I mean the other agreement on the parts that you are just putting to me.
we're going there. So what I'm saying to you is this, sir, that the catching agreement is one of multiple agreements, if we accept what the cooperation agreement says. Yes?
Okay, let me agree to that.
Okay? And only that component has a value of $500, the catching agreement. Yes?
I don't understand now.
I'm saying to you, sir, the catching agreement being one of multiple agreements as specified in the cooperation agreement that you disclosed. That agreement itself has a value ascribed of 500 Namibian dollars to that agreement. That is so?
Yes, sir.
Okay. And further, sir, my instruction is on that score, is that this 500 Namibian dollars was the only income that was due to Namgomar Pesca Namibia.
Your Lordship, just an objection with regard to the catching agreement between STR Holdings and Corporate Investment.
That is now the catching agreement.
Yes, Your Lordship. We went through yesterday with the applicant, and it has a usage fee. Not a catching, it's a usage fee at paragraph 4, Your Lordship.
Yes, the 500.
Yes, Your
Yes.
Lordship.
Now, that's some of the semantics, but it's
No.
fine.
Yeah. I pick it up. It's a catching fee, and on the other place, and paragraph 4, they are correct. It's a usage
But it
fee.
speaks to the same thing, Maloto. The
Yes.
semantics of rising for absolutely 0 points.
Okay.
Be that as it may, Malo. Whether it's a usage fee or catching fee, sir, that agreement has a value ascribed of $500. That is so?
That's correct.
Okay. So my instruction is, sir, that his employers, Namgomar Pesca Limitada and Asia, with the joint, after it is caught, they were the joint owners of the fish. You are not in a position to dispute that.
I'm not.
Okay. And they, at a higher level, had other agreements where they sold, distributed this fish together. Yet again, you can't say
I
anything
never
about it.
saw such agreement.
Yeah, you didn't see it, but you can't
I can't
dispute
dispute
that.
that.
Yes. Now, sir, as part of your bundle, sir, I have a statement in my possession that is marked AK32 that comes from a person by the name of Melanie Harrison. You know that person?
Rani Harrison, yes.
Okay. In fact, it is an official that you asked to assist you in an investigation.
That's correct.
Okay? Now, contrary to what you said earlier, sir, that not a single fish was exported from Namibia. Ms. Harrison actually says to the contrary, that all the fish was exported.
That is our statement.
Yes.
So,
Okay.
You say that is a statement.
it's correct, my
Okay.
Okay. In fact, she ascribes what was made offshore in the table, sir, contrary to what you are saying. Comment if you have any.
I don't have any comment on that.
Okay, good. Now, Lord, I'm just looking at what this witness had to say. My Lord. Now it is, we've established that Namgomar Limitada owned Namgomar Namibia, 100%. That is so?
That's correct.
Okay. So it's further correct that this applicant before court was not a shareholder of Namgomar Namibia.
It's correct, he was not.
Okay? Or owner, for that fact, because shareholder is an owner.
He was not the owner.
Okay. In fact, further, my instructions is that he never owned any shares in the holding company, sir.
That's correct.
Okay. So as far as we are concerned, sir, he was an employee.
That's correct.
Okay, good. Now, just to come back, Mr. Kanyangela, you spoke about the letter from the permanent secretary to Namgomar / Print. That is so?
That's correct.
Okay. Now, it is already before court as Annex C, my lord. But are you aware that as part of Section 35 agreement, that a local office and or representative is required?
I'm not aware of that.
Okay. It's already before court, sir. So as part of the Marine Resources Act, sir, I'm just saying, maybe you learned that, but as part of the Marine Resources Act, sir, there is a requirement that any foreign entity that receives a quota in terms of Section 35 must have a local office and or representative. No comment, I believe.
Oh, I don't have a comment.
Okay. So it is on that basis, sir, and that is my instruction, that this applicant before court was employed. Comment if you have
Can I
any.
dispute that?
You cannot dispute that. Thank you. Now, furthermore, sir, this was explained yesterday by the applicant, but I also want to clear that with you. The applicant advises, sir, that he was never a director of any of his parent companies. He's never director of Limitada, trading as SA. If you have a comment, you can. If not, we move on.
I can only comment that the letter from the Ministry of Fisheries and Marine Resources for the quota allocation of Namgomar Pesca SA was directed to him in a capacity as a director of that company.
Yes. No, it's fine. He already cleared it up with court. I just hold instructions to put that to you, sir.
To me, if he was not, then he was pretending to be a director of that company. I will take it like that.
We'll deal with that at trial. Now, so you said also that as far as you're concerned, Namgomar Pesca SA never existed. That is what you said?
Yes, it's what I have said.
Okay. Do you possess any documents from the Register of Companies in Angola to the contrary, that it never existed?
We only get a statement that went to look for that document, for those documents of that company.
I'm asking you, sir, do you possess anything?
I don't have any.
Nothing from the Register of Companies?
No.
Okay. Okay, good. Now, so you also testified that you did some investigations, sir, pertaining to, or you did some applied for mutual legal assistance from foreign countries on the affairs of Tundavala.
That's correct.
Okay? You say evidence received so far shows that 4.1 million was going or went there.
That's correct.
Okay? So can we accept then, sir, that this is still an ongoing investigation?
You can accept that.
So investigations in the matter is actually not finalized.
This case is a complex case. Although you put it to me previously, and I agreed to it, that we said previously that the investigation was finished. If I can recall, my testimony in that bail application, application, I indicated that by that time we have collected enough evidence that can be submitted to the Office of the Prosecutor General for a decision.
Okay.
And in
I can
this
take you
matter,
there.
Huh?
I can take you there.
Let him, sorry, let him finish.
That's it, please.
Let's proceed. Are you done now?
I'm done. You can just.
Okay. So in the very same application that you are referring to, you advised the court at that stage that investigations were still outstanding in Cyprus, Iceland, Denmark, Spain, Zambia, Angola, Dubai, and 2 other jurisdictions. You actually named 9 of them. That is so?
Is that in the application in May 2020?
Yes, we opposed further postponements, my lord.
Okay,
And that is what we were informed. And
okay.
it was on that basis that the court granted investigations. Yes?
Yes, but I cannot agree to some of the countries you just mentioned.
Those were your words. I can actually get the transcript of the proceedings if you want that.
No, it's not what he wants. It's what's necessary for this proceeding.
Indeed, so, my lord.
Please, let's go.
Yes.
I never submit any MLA with regard to Zambia,
Okay.
and I could not recall of mentioning such a name.
Proceed.
Yes,
So the other 6, at least that I mentioned now, you
I
confirm
might
that?
have mentioned them.
Okay. And as far as we're concerned today, sir, we have not received anything or any evidence that speaks to those jurisdictions.
In some jurisdiction, we receive partly evidence, which is still.
I just want to correct the parties. You received information, it's not evidence.
Thank you, my lord.
Okay, from some countries, we receive the information, but they were partly provided, and they were provided without supporting affidavits. And that is the process that we are still busy with, just to support what we have already submitted or what we are alleging in the main case in the case. So as soon as those documentations have been received, stated and obtained, can still be submitted and disclosed to you.
So, just to have you on record, sir, what we currently have is not the final disclosure for trial.
You can regard it as I said, some of the information that we are waiting, they are already part of the case file that was disclosed. The information were already part. Those are just some supporting information that what they are waiting for, that can also be placed on the case file.
Okay. I will leave it for argument, my lord. Now, I'm actually moving down on the points that you have raised, sir, yourself. Now, it is correct that there never existed any JV between Namibian nationals and Angolans pertaining to this case.
That is what I testify.
Okay, good. Now, you also say, sir, that the nature of the MOU was an issue. That is so?
Federal agreement, yes.
Okay. We can both accept that the discussions between Mr. Esau and Mr. Kawana are beyond the realms of this applicant. That is so?
That's correct.
Okay. It's above his pay grade even, to that point.
I can agree to that.
Okay. Now, sir, can we further agree that the agreement was consequently signed and went through cabinet to be gazetted?
That's correct.
Okay. From what I have, sir, I don't see any statement from a cabinet member or the former head of state to say that they were misled by any of the parties.
Dr. Kawana, I think he gave a statement where he indicated that these people who took part in this agreement, they were not sent by the state to represent them. That's why I said this MOU that was presented for gazetting, it was done in a dishonest manner.
So I'm saying to you, sir,
It was done?
excuse me, my lord,
He said it was done with?
there was a misrepresentation.
But yes,
I think his words were in a dishonest manner.
yeah. In any event, the state it had a good point. This MOU it's an understanding. It was not followed up by anything material. Even if it's gazetted, it's a hollow policy statement that is gazetted. Means nothing. No rights, no obligations.
My lord, we will deal with those
Yeah.
aspects come trial with the relevant witnesses. We didn't draft it. So.
Yes, that's. I just want us to move on from the
Yes.
MOU.
No, I understand, my lord. Now, sir, you also said that as a consequence of the bilateral arrangement, no jobs were created in this country. Do you stand by that?
I stand by that.
You see, there's evidence on the record from the applicant that at least 150 to 200 people actually had employment on the fishing vessels during the time of operation. Comment if you have any.
I don't have such records.
Okay. But you cannot also dispute that. I mean, if a ship doesn't drive itself.
I will dispute by saying these quotas that were being given, they were given to Namgomar Pesca SA, which entered into an agreement with the Asia Holdings or the Sameri Group. But in my investigation, when these companies was receiving money from Asia, although I could not say as to what was the agreement between them, I never see any payment coming from Namgomar Pesca Namibia reflecting as a salary for the job created.
You see, sir, if you look at that very same cooperation agreement, it will tell you that the day-to-day affairs of the execution of this quota was vested in Asia. So what I'm saying is, sir, and this is an instruction, the roughly 200 jobs were created as a direct result of this quota allocated. Comment if you have any.
I can't comment on that one.
Okay. So further, you said that this quota evolved around roughly, it was about 50,000 tons.
That's correct.
Are you aware of the total allowable catch during that period?
I'm not aware.
You cannot dispute that, and this is an instruction, sir, that about 2.4 million metric tons was allocated during those 5 years to everyone in the sector.
Okay, I can't dispute that.
Okay. So what I'm saying is, sir, this quota represented less than 2% of the total allowable catch.
I'm not good in mathematics and also not good in the fishing industry.
Okay. So
I
you can't dispute that. That's all.
I can't dispute that.
Okay. So we are saying, the applicant is saying, sir, and he already placed that before court, that the notion that people lost jobs because of Namgomar is incorrect. Comment if you have any.
Let me comment on that one. There's a possibility that Namgomar, when he was allocated quotas, there could be a possibility of people losing their job based on the fact that some of the companies which were employing those workers, their quotas were cut. This resulted in workers end up in strikes because the companies could not increase their salaries or their wages. Namgomar Pesca was a non-right holder. And evidence provided is that some of the companies that were employing some of the fishermen, their quotas were cut. And the possibility could be there for them to lose their job.
Okay. See, that is your opinion.
That is my opinion.
Okay. But what my client is saying, sir, contrary to your opinion, is that you are wrong.
That is his opinion.
Thank you. I just quickly want to see something. So, my instruction is, sir, that my client, at all times material to the allegations, was working on the instructions of João Barros. Comment if you have.
I cannot dispute that.
Okay. He did not act independently. Just want to close that point off, sir. Yes? You can also not dispute that.
I cannot dispute that.
Thank you. Lord, I just quickly want to canvass something with my client, if it's even necessary to pursue
Yes.
anything further. Not just one issue.
Yeah.
Sir, as part of your investigations, and from the disclosure I have, sir, this was the only Section 35 quota that you investigate. That is so?
That's correct.
Okay. So you did not take any other bilateral agreement or beneficiary of that bilateral agreement and say, this is the going rate for quota in this sphere.
That was based on the allegation that they found, or that was explained to me when the case file was handed over to me.
Okay.
That's why I did not follow any other bilateral agreement.
I didn't hear the last part?
I said that's why I did not investigate any other bilateral agreement.
Okay. So what we are saying is, or what I'm asking you rather is, you focused on the fees that are attached to the Angolan arrangement and did not bother with any other of the 26 arrangements we have as a country.
Yes, because with the investigation that I'm carrying where this accused person is involved, I do not see any money either flowing to the Namgomar, either flowing to the account of the accused people, that I could be of suspicion that they might come from a company that was awarded quotas, except on the Samiri group.
Now, my Lord, I just quickly want to see something. So my instructions are that, although you already commented, just want to close up, because I won't be long, my Lord. My client does not intend to abscond. Comment, if ever.
I cannot read what is in his heart, so
Okay. In fact, he's willing to report to you on a daily basis if need be. Comment, if you have any.
I'm not comfortable with it.
Okay. But there are people that currently are on bail that reports to your officers, be it to you or to anyone else in the ACC.
Yes, but not such in serious cases. I never saw people come to report there in a serious case like this one.
Okay. So because it's the first time for you that there's such serious allegations, because that's all it is, that people should not come and report. I'm saying, so in your mind, sir, where there are serious allegations, as you are labeling them, in those circumstances, you're uncomfortable with people reporting to the ACC?
I just not comfort with it because I have experience of people coming to report there, or given bail conditions to come and report there. But you may end up seeing people are not reporting. You might see a person when he's coming, he report Monday, and he also put the date of the next day. Because we don't have that capacity of controlling everybody who is coming to report at the reception. The setup of our office doesn't have a report made, a room made specifically for bail application, for bail reporting. They are coming to report at the secretary, and where there nobody can have control of them, investigators. Because we are not expected to be there anytime when a person is coming to report, based on the work and the setup of the office.
Okay, sir, if you have a camera, security camera, directed to a book wherein they must sign, I believe you have that facility, it's possible, then even 100 people can come per day and report at you, and you will see whether they report it or not. Am I correct?
What the book is, there's not really a setup camera that had been put up for a specific, just for a specific, to monitor the people who are coming to the
Yes. Council, move on.
Yes, my lord.
Move on. Let's finish up.
Okay? Now, sir, I further hold instructions that my client has not interfered previously. You have confirmed that, correct?
Yes, I have confirmed it.
Yes. He does not hold any intention to interfere with your ongoing investigations and or to tamper with witnesses that have already given statements. Comment if ever you have any.
Don't have any comment.
But
Okay.
he already answered that, Council. Let's not repeat questions.
Indeed so, my lord. I'm summing up, my lord. I'm dealing with the grounds. Sir, further, my instruction is that you, or rather, let me put it this way. It is not in the interest of the state or any other person for him to remain in custody, sir. Comment if you have any.
I don't have any comment on it.
Okay? Well, Lord, I'm not going to pursue anything further. I'll leave the rest for trial.
Yeah.
Thank you.
Council, I don't know the length of the re-examination. Will you be able to finish by 1, or do you want to stand over until 2:15?
Thank you, Your Lordship. Perhaps if the court can just give us an opportunity to go through the notes, and then to give us an opportunity to go through the notes, we can stand over until 2.
Yes, so-
but I'll be done, I think, after.
So the court will adjourn until 2:15, and then we will reconvene.
As you please, the court, Your Lordship.
2:15. Thank you.